Thank you very much for coming today. It's a pleasure to be in Poznań. And I want to thank all of those who had to work to change the date, because I was supposed to come at the end of March. I can no longer come at the end of March, so fortunately I was able to come a few months earlier. It's a little bit premature for me because the project I want to talk to you about is one that I've just begun. So I don't have a paper or anything, I just have some thoughts that I'm going to articulate today, and I'll see whether you have anything to tell me that can help me to take this project forward. I'm working for this year in Berlin. I'm on leave there, and to tell the truth, I went to Berlin for my academic leave without a project. I kind of faked a project to go there because the book that you mentioned earlier in your very generous introduction to me, which I published in 2022, left me exhausted, and I didn't have any idea of what project I would do next. But my host in Berlin at the Free University is an international lawyer, and he asked me, because he is an international lawyer, to give a talk in January about international law. As I said, I'm not an international lawyer, and I finally chose a subject where I thought I could say something about international law, and that's what I'm going to be talking to you about today. You mentioned earlier that I come from South Africa, and the one thing that I've hung on to, even though I've lived most of my life outside of South Africa now, is my South African accent, so I hope this doesn't make it too difficult for you to understand my English. You mentioned that legality has been the main theme of my work, and that's true, and it is the case because growing up in apartheid South Africa under a deeply authoritarian regime, I learned as a student and then as a young lecturer to value the rule of law. And I often think that one needs the experience of authoritarianism in order to really understand what a valuable resource the rule of law is. And it's been exploring that resource that I've spent the last, 40 years of my life trying to work out just what the rule of law is. And my current project, as you'll find out today, is still very much about the rule of law. The title of my talk actually comes from an article published in the South African Journal on Human Rights in the 1980s. Two South African lawyers, both human rights lawyers, were writing about the way that the Apex Court at the time was undermining the rule of law. And they called their article The War Against Law. And the war against law that I'm concerned with is a war that's been waged against law in the United Kingdom over the past few years by the Conservative government, aided by academic lawyers, most of whom come from the place where I did my PhD, my doctorate, that is Oxford. So I'm very interested in the way that this war has been waged with words against law, and in particular against international law. I'm going to start with a bit of a personal note. So I don't usually put my middle name, Ludovic, in I usually just have David Dyzenhaus. And the reason is that Ludovic is the anglicization of my grandfather. So this is, I think, unusual. The first real slide is my grandfather. So there's my grandfather on the right, Ludwig Dyzenhaus. And you can see there his grave, which is in Palmieri. He was a Polish lawyer, a Polish-Jewish lawyer, murdered during the early years of the German occupation. And I was very touched when sometimes Google is quite wonderful, looking for something about him just on the weekend. And I found this interesting looking site from the Polish Bar Association, and with the help of Google Translate, I managed to produce this translation from the Polish Bar Association, which, as you can see, I've learned that each year attorneys go and lay wreaths at Palmieri in order to commemorate the lawyers who were murdered there at the beginning of the war. And if anyone here is a member of the Bar Association, I'd be very grateful if you could put me in touch with them, because I would actually like to write to them about how moving I find this. And I've only been to Poland once before, actually in the early 90s, to visit that grave. And it does actually mean something to me that, and I think would have meant something to my grandfather, to know that his grandson would be lecturing at a Polish university. It would also mean a lot to my father. So my father had, as you can imagine, a Polish Jew in Warsaw during the war. He did not have an easy time. He was left scarred by this experience, never wanted to come back to Poland from South Africa. But he remained a lover of Polish culture, and among his books were the collected works of Mickiewicz. And I think he also would have been very touched to know that I was lecturing at a university which is called the Adam Mickiewicz University. Right, so that's the emotional bit of my talk got through successfully, and now I can get to the actual substance of my talk. So the focus of my project is on a piece of legislation that was enacted earlier this year in the United Kingdom. And the title of this statute is, as you can see at the top there, the Safety of Rwanda Asylum and Immigration Act, April 24th, 2024. And what it requires is that asylum seekers who arrive in the UK, usually on small boats from France, be sent to Rwanda, where their claims for refugee status will be processed. If successful, they will remain in Rwanda. And the point of this Rwanda policy was to deter asylum seekers from coming to the United Kingdom. Why would it be a deterrent? It would be a deterrent because most of them don't come from Africa, and Rwanda is a country which is actually notorious for its bad human rights record. So the idea was that you wouldn't want to come to the United Kingdom because you would end up in this place which is notorious for treating people rather badly. Initially, this Rwanda policy was just put in place by executive regulation. And those executive regulations were found to be inadequate by the Supreme Court in 2023. The Supreme Court of the United Kingdom found that Rwanda was not a safe country for the purpose of refoulement, that is, for the purpose of processing asylum claims. And that stopped the policy in its tracks. And the point of the statute was to, in a way, overrule the Supreme Court holding in its decision on the Rwanda policy. Now, as I'm sure you'll know, while I'm not sure whether the statute has been formally repealed, it's never going to be put into effect because the Conservative government was thrown out of office in June of this year and replaced by a Labour government. And the next slide that I have is from a speech by the new Attorney General, Richard Hermer. So Hermer, up until June of this year, was one of the leading human rights lawyers in the United Kingdom, specializing in international law. When Keir Starmer became head of the UK government, the new Labour government, he appointed Hermer, who's an old friend of his. Starmer also used to be a human rights lawyer, as Attorney General. And in October, so just a few months after the Rwanda statute became law, Hermer gave a speech. The speech was given at something called the Bingham Centre for the Rule of Law. You may know that Lord Bingham was one of the leading judges in the United Kingdom of the last century, very well known for a really wonderful book that he wrote about the rule of law. And to commemorate him, there's this annual Bingham Lecture, and it was given this year, just a short while ago, by Richard Hermer. And if you can read just the first few words from the slide, which come from the beginning of his speech, they're very strong words for someone who's just assumed a position as Attorney General to open his speech with, because he says there, as you can see, I watched with a mixture of fury, disbelief, and profound sadness as the previous government introduced the Safety of Rwanda Act. And then he goes on to say that he will leave it to his colleagues to make the obvious points about the workability and costs of the scheme. In fact, the scheme was regarded as completely unworkable. Not only was it very expensive, but it was well known that they would never be able to make a dent in the number of asylum seekers through sending people who'd arrived seeking asylum from the UK to Rwanda. In fact, I was going to put this on a slide, but I decided not to, but I'll say it. That the minister who guided the bill through Parliament, a man called James Cleverly, in his previous incarnation as holding a different job in the UK cabinet, had described the policy, and I don't know how well this translates into Polish, as batshit crazy. So he'd been overheard describing this policy in these terms. He denied afterwards that he had said this, but it was well known that he thought that this policy, which he then guided through Parliament, was completely crazy. Why was it crazy? It was crazy because it was never going to work. It was also, in a way, morally crazy to send asylum seekers to a country with a notoriously bad human rights record. But thirdly, I want to claim that it was legally crazy, and that's a difficult claim to make. And one can see this claim signaled in some of the words in bold in the quotation from Homer, who not only says that he was very upset by this act, but he says that the act contains what he calls constitutional heresies, a very strong claim to make, that this act was at least close to being unconstitutional in the United Kingdom. Why is that a strong claim? Because, as I'm sure you know, in the United Kingdom, judges do not have the authority to declare a statute invalid because it violates what are considered to be principles of the Constitution. I'll come back to this point a little bit later. And I use this quotation to set the stage for the whole book which I'm now trying to write about this episode, because I think one can tell a lot about the law, about legal theory, and maybe about the relationship between international law and domestic law, just by examining this one episode in the United Kingdom, the episode which concluded in the enactment of the Rwanda Act. And the whole of the book is going to be devoted to trying to unpack Homer's quotation, to set out the argument for his claim that the Rwanda statute contained constitutional heresies. So there are two questions that I'm going to be concerned with in this project. The one is, were there constitutional heresies? After all, this was an act validly enacted by the UK Parliament. In what way could it be said to be unconstitutional, amounting to a constitutional heresy? And why, another part of the quotation which I didn't dwell on, did Homer say that the assertion of parliamentary sovereignty in the Act was otiose, which means superfluous? I had to look that up in the dictionary myself, and therefore crass. And I think the answer lies in the fact that what the Act does is that it expressly disapplies fundamental international law obligations. So the Act has within it what in the UK gets called a privative clause. The privative clause says judges may not review this Act on several grounds. One of the grounds is that they may not review the Act on the basis that Rwanda is an unsafe country. Remember that just a year before, the Supreme Court had found that Rwanda was an unsafe country for the purpose of processing asylum claims. But what the Act does is that it deems, right? It says, Parliament has said that the country is safe, therefore from now on judges and anyone else treat the country as safe, whatever you think the facts are. It puts in place, as I say, an alternative set of facts. But it also disapplies all of the human rights protections that asylum seekers would previously have enjoyed. And that means that the Act can be implemented without the courts getting in the way. And these are the reasons why Homer claimed that the Act was heretical. But I do think that it takes quite a lot of work to show that the Act was, in fact, heretical. So these are all issues that I think are the kinds of issues that are familiar to lawyers. But there is also a political side to my project, and I think, although I'm starting to lose my way, I know where I am, that I want to explore this political side in this project. And there is actually a Polish angle to the political part of the project. So the whole project of undermining law in, as I understand it, in the rule of law and international law in the United Kingdom is driven by something called the Judicial Power Project. The Judicial Power Project is hosted by one of the leading right-wing think tanks in the United Kingdom, Policy Exchange. And the two masterminds of legal masterminds and also the driving force in the Judicial Power Project are John Finnis, now a retired Professor of Philosophy of Law in Oxford, and his former supervisee and now main protege, and also now a Professor of Law in Oxford, Richard Eakins. Now, I don't want to claim that every person that Finnis has supervised turns out to be part of this project. Finnis was one of my supervisors. I'm not in favor of his Judicial Power Project, but I think there are significant links between the people on this slide. So the links which I've tried to indicate with the blue lines go directly from Finnis to Richard Eakins, his student, now a Professor of Law, to Conor Casey, an Irish jurist now teaching at the University of Surrey in England. And they also extend across the Atlantic in something called the Common Good Project to Adrian Vermeulen, a professor at Harvard University. And the links do have some connection to Poland as well. Why do they have a connection to Poland? Well, the Adrian Vermeulen is an explicit follower of someone who I think is probably very well known to all of you, and that is Legutko. And it's also the case that, despite my Polish origins, I can't pronounce Polish names. If you pronounce his name Janek, yes. So he was, as you'll know, Minister of Justice, I think, is that right, under the Law and Justice Party? Education. And he was responsible, as I understand it, for founding the Copernican Academy, a kind of counterweight to the established Academy of Sciences in Poland. And among its fellows are Conor Casey and Adrian Vermeulen. So there are these kind of transatlantic, trans-European connections between people who are, in a way, rethinking the democratic project and rethinking the role of law in our society. And I thought I would just draw your attention to these links right at the beginning. I'll have a little bit more to say about Legutko in a moment. Now, I want to make a rather controversial claim now, and that is that the real roots of the theory that undergirds this movement known as common good constitutionalism are in a pre-war Germany, and in particular in the thought of two German fascist political and legal theorists, Erich Voegelin and Carl Schmitt. Now, I assume that Schmitt is someone who's well known to people in Poland, at least to many of you in this audience. He's become a very influential figure in the last few years in English, but one of the leading legal and political theorists during the Weimar period and since. Erich Voegelin, I don't know whether that name conjures up anything for people in this audience. Have people heard of Voegelin?
Yes, it's reading of data.
Yeah. So he's
been published in Polish.
Yeah, so he's a very important figure in the history of ideas, but he actually has an outsized influence politically in the United States as one of the leading thinkers of the right. And why are these two people important? If I go back just for a moment, Vermeulen is, and this is not an exaggeration, a disciple of Carl Schmitt. And John Finnis has been influenced throughout his career by Voegelin. Voegelin himself, in the 1930s, while German, he was in Austria, wrote a book in praise of the Dollfuss regime when the Austrian state became authoritarian. And he takes over in this book on the authoritarian state wholesale Schmitt's legal theory. So I do think that the roots of what gets called common constitutionalism these days can be traced back to these two figures, Erich Voegelin and Carl Schmitt. Erich Voegelin is probably the most influential thinker on the right in the US at the moment, actually far more influential than Schmidt. I also want to mention something that binds together some of these figures, and that's a doctrine known as integralism. And this is, as I understand it, and I need to do a lot more work on this, a deeply controversial version of Christianity, mostly of Roman Catholicism. So I want to emphasize that I do not equate integralism with being Catholic. I know that this version of Catholicism is deeply contested within those who adhere to Roman Catholicism. And what integralism tries to do is, as I say on the slide, it seeks to integrate state and society by enforcing on citizens a set of moral virtues so that they can flourish in the community organized around the common good, a common good which the ruler promulgates. And this is how you get the idea of common good constitutionalism, because common good constitutionalism is the legal theory of this political movement known as integralism. Now, this idea of integration is rather strange, at least to me, because what it does is that it requires that the state be made the instrument of one version of one faith, and how that instrument should be used varies actually quite a lot from integralist to integralist. Finis, for example, long ago advocated a reversal of what he called the inflow of immigrant, non-citizen Muslims to the United Kingdom. He's also an advocate of the Great Replacement theory. What is the Great Replacement theory? The Great Replacement theory, which I should be familiar to everyone here, is the theory that people are coming from somewhere else into our country. They're breeding much faster than we breed, and they're going to take us over. So we've got to get rid of them. Vermeulen has recently argued for limiting immigration to the US to Catholics. So this is all in the service of this kind of integration of the community around the doctrines of a particular version of one faith. And the problem is that once we're in the world, which they often call the post-liberal world, I don't think there's any principal distinction that can be made between soft and hard integralism. I don't know why I have this thing at the bottom. Let me try to get rid of it. Is our tech person still here? No, anyway. It's very difficult, once we're in this post-liberal world, to make a distinction between the different kinds of authoritarianism that will be in play. I've done a lot of work myself on Weimar legal theory. And I came up with a term some years ago to describe Carl Schmitt's theory. And it's a rather cumbersome term, but I think it does capture something that's interesting about Schmitt's theory and also about the theories of the people that I had on the slide earlier, Finis and the others. So the term is negatively prescriptive theory. What is a negatively prescriptive theory? It's a theory that doesn't actually tell you what the positive content is that the theory is prescribing. All it tells you is what the theory is against. And all of the people on their slide earlier, I think, are united by being negatively prescriptive theorists. There's some vague understanding of what they're all positively in favor of, but all that we can know for certain is what they're against. And what is it that they're against? The idea of negatively prescriptive theory is that it's an ideology that is an anything but ideology. In this case, anything but liberalism. There's a hatred of liberalism. Liberalism is conceived as the demon, and that's what they share in common. And that's why I find so evocative the title of one of the books of Legutko's that's been translated into English, The Demon in Democracy. I've read two of his books, The Demon in Democracy, and another book called The Cunning of Freedom. And the argument in these two books is much the same. We had communism, which was totalitarian. It's been replaced by liberalism. Liberalism is also totalitarian, and it's much more successful than communism in its totalitarian ambitions. And so we need to get rid of liberalism in order to achieve true freedom, which I think is the freedom of this integral community. And just to reinforce the point that I was trying to make earlier, one doesn't have to be Catholic or even Christian to hold onto this ideology. For example, one of the most influential figures on the right in the US, and the close bonds between this person, Vermeule, and the others, is an American-Israeli called Yaron Hazony, who's proud to be known as what he calls a Judeo-nationalist. So you can be Jewish and subscribe to a version of negatively prescriptive theory. You can also have no religion at all. And that's why I cite someone who I think his name will be familiar to you, and that is Steve Bannon, who, as far as I can tell, is some kind of a pagan, if one's going to ascribe any faith to him. But he also subscribes to the tenets of negatively prescriptive theory, in that we know that what he's against, maybe not what he's in favor of, but we know that he's against liberalism. And that's why a lot of the people in this group are attracted to the label post-liberal, or a label that they get from Viktor Orban, which is illiberal. So this is the political theory that lies behind this legal project known as the Common Good Project, or Common Good Constitutionalism. So what are the implications, the legal implications? So moving away from the political, more in the direction of the legal. The implications for law. So I start here with a quotation from an avowed Nazi legal theorist from 1935, Georg Dahm. He was a member of the Kiel Law Faculty, which was notorious even at that time for being a Nazi law faculty. And he remarked of Schmitt in 1935, and this remark was meant to be approving, that all of Schmitt's works were, from the ground up, trained on one target: the unmasking and destruction of the liberal rule of law state and the conquest of the legislative state. So this is how Georg Dahm understood Schmitt's project. But I think there is a difference between Schmitt's project and the project of the people that one can think of as common good constitutionalists. And that is that the project of the common good constitutionalists is much more subtle than Schmitt's project. And I think they've learned how to be subtle, with their principal teacher being the person I mentioned just a moment ago, that is Viktor Orban. Because I think there has been this learning curve initiated by Orban, whereby lawyers around the world have learned that you can preserve the facade of democracy and the rule of law while hollowing out these institutions from within. And from what little I know about Poland, which is mostly from the work of Wojciech Sadurski, this was a project that was fairly successfully undertaken in Poland under the Law and Justice Party. And so the focus of my current research is to try to understand how a similar project unfolded in the United Kingdom, brought to a stop, perhaps temporarily, by the election of a Labour government, but still a project with many of the same hallmarks as projects that we've seen in the world elsewhere, particularly in Central and Eastern Europe, and which I think we're likely to see in the next few years under the presidency of Donald Trump. Right, so back to the UK, and to focus on the statute, the Rwanda Act, and the topic which has informed my life's work of legality and the rule of law. So as I've already suggested to you, what the statute did, the Rwanda Act, is it deemed to be safe a country the highest court in the land had found unsafe. And so it put in place by fiat, just by enacting a statute, a set of alternative facts. In addition, it almost entirely ousted or prohibited judicial review of the implementation of the statute, review on the basis of the rights of asylum seekers in international law, including in UK statutes that incorporated these rights. I apologize for constantly looking back at my slides. I actually had a printout of my slides, but I left it in my jacket somewhere else in this building. But the UK's treatment of asylum seekers was not made lawless in the following sense. So often when people are trying to work out what the content of the rule of law is, there's a standard contrast drawn between the rule of law and the rule of men, where the rule of law is meant to give us something predictable, certain, we know in advance where we stand, whereas if we're subject to the rule of men, we're subject to the arbitrary whim of individuals. They just make whatever decision they want to at the moment. And if that's one's understanding of the rule of law, that is to be contrasted with the arbitrary rule of individuals, then I don't think it can be said that the Rwanda Act in any way is inconsistent with the rule of law. Because under the Rwanda Act, if you arrive in the UK as an asylum seeker, you know for certain, as long as the statute can be implemented, what your fate will be. You will be sent to Rwanda to have your asylum claim processed. You're subject to, as I put it on the slide, to a rigid deportation rule which requires officials to deport any asylum seeker. And the rule, in fact, makes the regime for asylum seekers a lot more certain than the regime that previously existed. Because under the old regime, you would make your asylum claim within the UK. You would then be subject to a series of official and tribunal decisions which would have regard to the international law criteria that have been incorporated into UK law for determining whether you should be given refugee status, and that puts your fate in the hands of officials and tribunals. And so you had an uncertain fate as an asylum seeker, subject to decision-making by a bunch of officials. Now you know for certain what your fate will be if you arrive in the United Kingdom. You will be sent to Rwanda. And the reason that the rule can do this work is because the main difference made to the legal landscape that had existed before by the Rwanda statute is that the provisions in the statute not only declared Rwanda to be safe for the purpose of processing asylum claims, but also explicitly disapplied the legal rights that the asylum seekers would otherwise have had by saying that these provisions in human rights law, provisions which have been incorporated into UK law by statute, by Parliament statutes, do not apply to the situation of asylum seekers. So then the question becomes, the question which I alerted you to earlier, was the Rwanda statute, legally speaking, crazy? Was it consistent with the rule of law? Did it contain constitutional heresies, as we saw the Attorney General Richard Hermer claim? And so here's the answer that comes from the common good lawyers. So mainly Richard Eakins, but people who also work with him. So they say no, there's nothing wrong with the statute from the perspective of the rule of law. The asylum seekers were deprived of these rights by valid law enacted by the UK Parliament. The UK Parliament is the supreme legal authority in a democratic country. Moreover, as I suggested a moment ago, if what the rule of law condemns is the arbitrary rule of men, the statute is legally speaking the opposite of arbitrary, since certainty has been brought by law to an otherwise uncertain situation. Finally, and this is a point I'd be happy to talk about more in the discussion, I'm just going to say a little bit about it. The UK is a dualist jurisdiction in that international law obligations incurred by the executive have direct effect internally only when explicitly incorporated by Parliament, and the corollary of that is that if Parliament explicitly disapplies international law obligations, then those obligations have no purchase internally within the United Kingdom. So the further claim that the common good lawyers make is that the statute is not only consistent with the rule of law, it's also consistent with international law, because international law delegates to the UK Parliament the authority to decide what international law obligations apply internally within the United Kingdom. So on this basis, it looks like everything is fine. You might dislike the statute, morally speaking. You might think, as I put it earlier, that it's morally crazy, but legally it looks watertight. But I think there is a problem for this statute in the claim that it's legally watertight, consistent with the rule of law and international law, and that is that the deportation rule is on the surface in conflict with other valid rules, rules which remain valid in the United Kingdom, the rules that hitherto governed the situation of asylum seekers and which remain incorporated into UK law by statute. So now I want to try briefly to explain Hermer's charge that the Act contained constitutional heresies. And in order to show why the Act contained constitutional heresies, and I should mention that I've just begun this task of trying to demonstrate this, I turn to the closest thing, as I put it on the slide, to a constitutional Bible in the United Kingdom, and that is the great English lawyer A.V. Dicey's introduction to the law of the Constitution, first published in 1885. So I don't know whether Dicey is well known in Poland, but this book that he wrote in 1885 does in a way remain the Bible of English constitutional law. It can only be the Bible of English constitutional law for a bunch of reasons. One is that the UK Constitution, somewhat inaccurately, is said to be an unwritten constitution. What does an unwritten constitution mean? It means that there's no constitutional document, as you have in Poland, as we have in Canada, which sets out the rights and liberties which all the citizens enjoy under this constitutional order. Rather, the Constitution comes from various sources. One is common law, so principles developed over time by judges, various statutes that are considered to embody or state constitutional principles, various conventions, just practices that have grown up over time. And because Dicey was the first to try to set out a complete theory of the English Constitution, and because he was a brilliant jurist, very versed in both legal history and political theory as well as legal theory, his book has immense weight in English constitutional law. It's considered, as the Encyclopedia Britannica said, I just discovered, as part of the English Constitution. So if you want a source to find out why Hermer's charge might be right, that the Rwanda statute contained constitutional heresies, the first person I think you would go to, or the first authoritative text, would be Dicey's lectures on the law of the Constitution. I should also mention that the reason that the book is called Lectures is that the book was first delivered to undergraduate law students in Oxford as a set of lectures, and then lightly revised in order to turn it into this constitutional law book. But that means that it's really accessible, because Dicey first explained his theory to people who at that point knew nothing about law. Now, some of the things that Dicey says in this book seem to support the common good constitutionalist claim that there was nothing wrong, legally speaking, with the Rwanda statute. So Dicey begins the book by saying that one of the constitutional fundamentals of the United Kingdom is parliamentary supremacy. Parliament may make any law it pleases. And a direct implication that he draws from this constitutional fundamental is, as he puts it, that a modern judge would never listen to a barrister, a lawyer, who argued that an act of parliament was invalid because it was immoral or because it went beyond the limits of parliamentary authority. And then he goes on in the same page to say that, of course, a court would never listen to a barrister who argued that an act was invalid because it violated international law. So if that's right, then it seems that everything is fine with the Rwanda statute. But Dicey regarded parliamentary supremacy as only one of the two major features of the English Constitution. The other major feature, he said, the second of these features, so this is a quotation, which, he says, is closely connected with the first, is the rule or supremacy of law. So there are two major principles in the English Constitution, according to Dicey. First, parliamentary supremacy. Second, the rule of law. And he says these two are closely connected. And notice that the double occurrence of the word supremacy here. It occurs in regard to parliamentary supremacy, but it also occurs in regard to the supremacy of law. So for Dicey, parliamentary supremacy had something intrinsically to do with the supremacy of law. And trying to work out exactly how this worked in his theory is not that easy to do. I'm hoping to make some headway in this regard in my project. One of the implications Dicey saw to the second of these features, the rule or supremacy of law, is, as he put it, that no man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. And I think that as soon as one spends some time trying to work out what he intended to convey in this, telling us about this feature of the rule of law, one can start to see why it might be the case that there was at least something legally problematic about the Rwanda statute. On the one hand, it's a valid law, properly enacted by a democratic parliament, but on the other hand, it can't be said that the asylum seekers who arrive in the UK are being treated in accordance with the rule of law if one thinks that a defining feature of the rule of law is that when a decision is made by an official that affects your important rights or interests, you should be able to contest that decision before the ordinary courts of the land and establish your rights in the ordinary legal manner before the courts of the land. Why? Because what the Rwanda statute does is it disapplies so much of the law which would ordinarily apply to asylum seekers who end up in the United Kingdom. So back to the common good argument for why there's nothing wrong with the Rwanda statute. Their argument is that Parliament may make any law it pleases, so the principle of parliamentary supremacy, and so may override international law obligations. Remember that the UK is a dualist country, meaning that at least international law obligations incurred by the executive through treaty making only have direct effect within the United Kingdom if those obligations are incorporated into law by statute. And even if they are incorporated into law by statute, Parliament may, in a subsequent statute, override those obligations, or, as in the case of the Rwanda statute, disapply them for a particular situation, that is the situation of how asylum seekers should be treated. So Parliament may make any law it pleases, override international law obligations, and further deportations are governed by a clear rule. Therefore, so the argument goes, the Act is consistent with both the rule of law and international law. So that's the common good constitutionalist argument. The argument that I want to oppose to that is based on this sentence from Dicey: no man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. Now, I think it's really interesting that as this bill was becoming law, there was a significant number of members of Parliament from the Conservative Party who were very concerned about the implications for the rule of law of this statute. And so they insisted successfully, that the statute retained what I call a sliver of judicial review. So while the statute gets rid of most of the kinds of judicial review that would ordinarily be available to asylum seekers, it does retain a little bit of judicial review, and it retains it in Section 4. So it still allowed asylum seekers to bring an application on the ground that the Republic of Rwanda, so there's a quotation from Section 4, is not a safe country for the person in question, based on compelling evidence relating specifically to the person's particular individual circumstances, rather than on the grounds that the Republic of Rwanda is not a safe country in general. So what does this judicial review permit? This section, it wasn't exactly clear, but the idea seemed to be that if you could show that you in particular would be unsafe if sent to Rwanda. So if you had some prior connection with Rwanda, that meant that the Rwandan government was likely to victimize you, then you could make an application for judicial review, but otherwise not. And in particular, you couldn't make any application for judicial review on any grounds that would bring into question the statute's deeming of Rwanda to be a safe country for the purposes of processing asylum claims. In the second chapter of this book, which I'm still struggling to write, I'm focusing on just one document which was produced by Eakins and two other lawyers, one of them including Casey, where they argue very vehemently that it was a grave mistake for the statute to leave in place even the small bit of judicial review. Why they worried? They thought that clever human rights lawyers would use even the small gap to raise questions about the viability of the statute as a whole. And what they really wanted was the statute to exclude any kind of judicial review, just because they were very worried about human rights lawyers, including the person who became Attorney General of the United Kingdom, who was one of the leading human rights barristers specializing in international law. And so they showed that what they desired was unlimited executive power, the opposite of the rule of law. So this rigid deportation rule, while in one sense it might seem like it's perfectly consistent with the rule of law because you know for sure what's going to happen to you if you arrive in the United Kingdom as an asylum seeker, is actually a rule that I think is inconsistent with the rule of law. Why? Because it consigns you to an exercise of what we might think of as prerogative power. And while I haven't yet explored this idea in my project, it is an idea that I want to explore. I think there's a kind of interesting analogy that can be drawn with something that happened in the United States before the Civil War. So a problem that's long fascinated me in United States jurisprudence is the problem of fugitive slaves. So if we divide up the United States, and this is crude, before the Civil War, into southern states and northern states, and say that all of the northern states were abolitionist states, all of the southern states were slave-owning states. That's not the way it worked. Things were more complicated than that, but just for the sake of the point, let's assume that that's the way things worked. Then fugitive slaves were enslaved people who managed to escape from the south to the north, and then they would be subject eventually, and this was one of the causes of the Civil War, to a fugitive slave law. If you were found to be a fugitive slave in a northern state, you were given a very bare judicial hearing, and then you would be rendered back to your owner in the south. And there was immense jurisprudential debate and debate between judges in the north about what to make of fugitive slaves. It's a very interesting problem because, in a way, the question for the court was, is this a piece of property that should be returned to its owner, or is this a human being who's applying for a writ of habeas corpus and wants to be freed from a captivity on which the northern states at least frown? And I think that asylum seekers are put in much the same situation as fugitive slaves were in the United States, because the fugitive slaves were also subject to a rigid, call it deportation rule. If you were found to be a slave who had managed to escape to the north, you were sent back to the south. Is that consistent with the rule of law? I don't think so. That is, if we think that the rule of law is all about protections that people should normally enjoy and that they can go to an independent court to get a ruling on. And I think one can make exactly the same claim about the deportation rule under the Rwanda statute. It's very clear, but I think it clearly violates the rule of law, even on Darcy's understanding of the rule of law. And because what I think the common good lawyers wanted to achieve was unlimited executive power, which I think is the opposite of the rule of law, a prominent UK public lawyer at one point renamed their project, the Judicial Power Project, the Executive Power Project, and this is what I think they're all about. Now I'm getting, you'll be relieved to know, to my final slide, the end of my talk. And in the abstract for the talk, I claim that the common good, the idea of the common good, differs sharply from the public good at which the rule of law aims with its intrinsic commitment to the authority of international law. And I'm happy to try to answer questions about this claim. I may not be able to answer them because, as I've said now a few times, I'm very much at the beginning of this project. But there is an intuition that drives my current work. And the intuition is that nothing can be said to be truly for the common good of a pluralistic, complex society, democratic in that it is not subject to authoritarian rule and governed in accordance with the rule of law, unless the claim about the common good, what is in the common good of everyone in the political community, can be made public. So I'm very interested in this idea of the public and trying to work out what might be distinct between saying that something is for the common good of a community and saying that something is for the public good of that community. And my thought is that the transformation into public good requires, first of all, that if you have a policy which you claim is in the common good, that the policy in question be enacted into a law that complies with both the domestic and the international human rights commitments of the jurisdiction. That's the first point. The second point is that such compliance is testable in a judicial body independent of the executive. And then the third claim that I want to make in this project is that the Rwanda policy could not be made public, which is why the legal arguments in its favor were, as I think, so bad. They were all false or fake legal arguments. Right, so that's what I'm working on now. That's where I've got to at this point, so now I'm happy to take questions. Thank you for your patience.